So we're going to start off with a couple of concur, not concurs, and then we'll move on to Heather. I think we're going to move on to that. What was the House bill, the Montgomery County, the House Bill 51, and then we'll get on to the Juvenile Restoration Council, and then we'll go to Senate Bill 478. Okay, so go ahead. Who's got the first concur, not concur?
Senate Bill 159, Local Government, Humane Society, and Animal Control Officers' Education and Training Requirements. Jamie.
All right. Take your time.
Senate Bill 159, this is the concur, not concur.
Right, so this, let me just pull this up. It's a clarifying amendment to make sure that Baltimore City is included in the bill.
They took everything else?
Right, it just rewords the
More
line.
invested in that bill now than Jeff is.
You want to make a motion?
So there's been a motion to concur. It's been seconded. Is everyone okay with that?
Yeah.
Yes, that's right.
That may
Yeah.
be my signature legislative achievement.
All right,
What is he looking for?
the cross file.
They didn't put that on their own bill, they only found it later. So the motion on 281 would be to conform it to the Senate bill as we just passed it,
Or as the House.
as the House passed it. Yep. It's House Bill 281 is to conform to the Senate bill as the House passed the Senate bill.
It's a weird process where the House bill came over, then our Senate bill went over there. They found something, added something on the Senate bill, and now we've got to add it back onto the House bill, which we had possession of.
What are you talking about?
Same bill. We're just making the House and Senate bills the same.
Oh, okay.
Is everyone okay with that? Okay, great.
So favorable with amendments.
Favorable with amendments. All right. Say, what's the next concur, not concur?
So this was Senator Waldstreicher's bill. The bill established a civil cause of action that a financially exploited susceptible adult or older adult may bring against a financial exploiter of the adult. So the House's amendment, they put back in the bill language that JPR had struck regarding compensation of the outcome. So the struck language read, "A party who brings an action under this subtitle to recover for injury or loss and is awarded compensatory damages may also seek, and the court may award, an amount not exceeding 3 times the compensatory damages and prejudgment interest." So JPR had taken out that language, and the House put it back into the bill.
Thank you, Mr. Chairman. It was our intent to take out punitive damages, and we believe that striking treble damages in addition to punitive damages was an accident and not purposeful, and so we returned treble damages on the House side, and I think that was the intent of our committee at the time. So I would move that we concur with the House bill.
We're going with treble damages? It sounds pretty punitive. It's pretty punitive.
Oh, really? You don't say.
So you could get treble damages just on a preponderance of the evidence standard?
That's correct. There are other circumstances in our law where you can get treble damages.
I'm sorry?
I mean, yes, treble damages are often on a preponderance standard. In fact, treble damages are only on a preponderance standard. You don't get treble damages in criminal law.
No, I'm talking civil law. This is civil.
Sure.
And it's not using treble damages and punitive damages. So we struck out punitive and less treble.
That's correct.
And that's what we're going back with. So we're going to leave treble but keep out punitives. Is that where we stand now?
Yes, sir. Yes. We are dropping
Wow.
punitive and we're keeping treble.
I'm just, susceptible who has been subject to financial there is exploitation. All right, it is financial exploitation. I mean, there is an element of malfeasance in there. So, what the heck? Yeah.
It's been seconded. Is everyone okay? All right. We have one more?
Yeah. This is a receipt.
If JPR wants to be consistent with its previous action, it would be not recede because JPR already determined not to concur with the House amendments on the cross file.
Same, so stay the same.
So to stay consistent, it would be not recede.
You already appointed a conference committee for this one, didn't you?
I don't know.
I think so. Yeah. Yeah.
Same people.
So not the receipt, same posture as the last one, as a cross file. Same, who's on that? Do we remember?
I can pull it up if you give me just a second.
Okay.
It's SB 105.
Okay. Well, let's go on to, so Heather, then, House Bill 541.
This bill requires a contract for the sale of a single-family residential real property in Montgomery County to contain a notice that school boundaries designated for the property may be subject to change. The bill also provides that a contract subject to the bill's provisions will not be void if the notice is not included in the contract or if it's not initialed by the buyer. House Bill 541.
What's that? Second. Motion to approve was accepted.
Montgomery County. Are you guys cool? All right, excellent. Thank you very much, guys. This is groundbreaking work. All right. So now we'll go on to, it's important to us, all right? It's cool. All right. We're going to go on to the council.
Do you want me to slide?
Here, yeah, so just... You want to speak to it? Are you going to speak to that?
The committee amendment then would be just the ROCA funding and also the continuation of the council. I think I've got that right. Okay.
So is committee okay with that? All right. All right, up, unanimous. All right, great. All right, now let's do, so we've got Senate Bill, Josh, this is you. It's Senate Bill 478. Can you swap with Jamie? Yeah.
So before we get into the bill, I think it would probably be useful to just give some background information on 287G agreements. It's Senate Bill 478. So there's a provision of federal law, which is Title 8, Section 1357G, which is often called 287G, which allows the U.S. Attorney General to enter into agreements with local jurisdictions to have the local personnel perform immigration enforcement functions. Currently, 3 counties in the state, Cecil, Frederick, and Hartford, have 287G agreements, and they all follow something called the jail enforcement model, which means that they're limited to activities which take place in the local correctional facilities, and they have 3 main components. So first, they allow the local personnel to screen inmates for immigration status information. Second, they allow the personnel to share that information with immigrations and customs enforcement. And third, the agreements formalize a practice of honoring ICE detainers. These are administrative requests from ICE that a correctional facility detain an individual for up to 48 hours beyond when they would ordinarily be released in order to facilitate a transfer into ICE custody. So just with that background, going straight to the reprint, which again is Senate Bill 478 with amendment number 68878/1.
Can we get copies of that?
Yeah, should have been distributed, I don't know about today, but in the last few days.
When was it initially distributed?
Sometime earlier this week.
478?
That's it.
Yeah, thanks.
You just say it again, it's just not.
Do you want to wait until they're have it?
Just from a quick look, I'm assuming that this bill is essentially just attempting to look forward rather than looking back. Is that?
But there are a couple moving parts I want Josh to explain, then I can dive in as well, but make sure everyone gets a reprint.
Facilities?
So, just wait till, it's the bill that, as it came in, it's just those 3 facilities that exist right now, but it's, as amended, there are a couple more components to it.
Well, so it was unclear to me why he's getting that.
Yeah.
So I was under the impression in the bill, even as it came in, that it was only private facilities. In those 3 counties, they don't house people in private. They're all housed out of the jail, the public jail. And then the House sponsor got up and claimed he had an AG letter that this didn't affect 287G programs. I read someplace else. Because they're all publicly run, they're not in a private facility.
So the bill as it came in actually, I believe if you go, I mean, the amendments kind of changed the way it works, but in, as it came in section 1-103, subsection C, involves immigration detention agreements by the local governments. So this is kind of a distinct thing from the 287G. This would be a situation where the local jurisdictions are housing immigration detainees kind of on a semi-permanent basis, rather than holding them until ICE can pick them up. These would be individuals who are currently in deportation proceedings and are being detained for the course of the proceedings. And I believe there are 2 counties, Frederick and Worcester, which, separate from their 287Gs, Worcester doesn't have a 287G, but separate from a 287G, they have a contract with the federal government to detain these individuals who are going through removal proceedings. So the bill would have banned those, but there was some question as to how it was originally drafted, whether that would have unintentionally bled over into the 287G programs. And I think there was, part of the amendment should address that particular issue. Okay, so turning to the reprint, which again is Senate Bill 478 with amendment number 688478/1. The first 3 pages of the bill or 2.5 pages, are definitions. Starting in the middle of page 3. Yeah.
Question right away. So, immigration detainer agreement means any contract agreement, intergovernment services, or memorandum of understanding that authorizes the state or local government to house or detain. And then it says, does not include any agreement entered into before July 1st, 2021. So this, is that talking about this immigration detention agreement? Is that talking about the 287G and the program in Frederick County?
No, so the intention was for that to not touch the 287G, under which, so, right.
I'm saying,
Well,
what I'm saying is Frederick County's agreement under this is grandfathered in because it's prior to 2021. So is this grandfathering in effect the 287G and the housing?
That's correct, but let's keep going, because so what it does is it does grandfather in those 3 jurisdictions that have them going on right now, but you'll see later that it does curtail.
I know. I
Okay.
want to make sure I'm starting. So it grandfathers in 287G housing in Hartford,
Cecil and Frederick. Cecil and Frederick.
Cecil and Frederick. Those are the ones that have the program.
Correct.
Okay.
So starting in the middle of page 3, the bill as drafted has some language stating the findings of the General Assembly. The amendment strikes all of that from the bill. Turning to page 4 in the new section 1-102, subsection A essentially prohibits a state or unit of local government from entering into agreements to facilitate private immigration detention in their jurisdictions. Subsection,
Hold on a second. So who's doing that? No one's doing that.
currently no jurisdiction.
So
has
A, no one. Okay.
Subsection B would provide that in the absence of an agreement for a private detention facility, if such a facility was being constructed without an agreement, before issuing a zoning variance or a permit for that, the local government would have to provide notice and allow for public comment.
So private actor comes in independently, it just says you got to have these public hearings.
Subsection C bans immigration detention agreements between the state and units of local government. So again, this covers the situation rather than what happens under 287G, where a local jurisdiction has detained an individual on suspicion of having committed a crime, and ICE wants to come in and have the local jurisdiction detain that individual for an additional period of time. This would be the situation where an individual has already been placed into deportation proceedings by ICE, and they're being detained while that case plays out in the immigration court. So this would ban agreements between the federal government and the state or a unit of local government to house those detainees in the local facilities.
So you're saying some of these, does everyone understand? So some of these agreements are just literally for warehousing folks. Could be from different jurisdictions, could be from the jurisdiction.
Wait a second. So let me ask this. So I think Frederick County has one of those agreements where they house people locally, correct?
Yeah, they do.
So if Frederick County's not going to house people, how does it help an individual to be housed then in Harrisburg, Pennsylvania? Because it's not like they're not going to be housed. The federal government is asking for people to hold them. And so if they're not going to be held in Frederick, they're going to be held, and they're from Frederick or Montgomery County, they're going to be held in like Wheeling, West Virginia or Pennsylvania. Like, how is that a good policy?
No, so that's the discussion I had with folks, the advocates in this space, and and counsel, you can correct me if I'm wrong, that this is a population that tends to be moved around. This is what the testimony was. All right, that the population tends to be moved around a lot anyway, and that on balance, this was the best policy to move forward to just say, look, we're not going to engage in this type of housing folks because it's a population that tends to get moved around anyway. But I see what you're saying because that was brought up.
Well, what's going to happen is every red state is not going to pass this bill. They're not going to pass this bill in Kentucky and West Virginia and Tennessee. So instead of somebody being housed who's from Prince George's County being housed in Maryland, they're going to get shipped down to Kentucky. So how is that good? But it's not because it's a federal crime. They're going to find a place to house them, and there are going to be places that'll be happy to take them. So how being 6 hours away, does that do any good?
Senator Hetland, go ahead.
No, you're not wrong.
Let's keep marching through.
So subsection C would additionally prohibit an agent or employee of a state or local correctional facility from allowing federal immigration authorities to access any area not accessible to the public. And there is a carve-out there where that would not apply if it's authorized under a current 287G agreement. Moving on to the new section 1-103, subsection A concerns ICE detainers, and subject to an exception, a state or local correctional facility essentially would not be able to honor an ICE detainer. And then the exception would apply if the detention is authorized by a current 287G agreement and the person being detained has been convicted of or has a pending charge for a crime of violence. So as the amendments are currently written, that would be as defined in section 5101 of the public safety article. Sorry, this is
Number 505, you're down on, underline 21 toward the bottom, right?
correct.
So the amendment to the amendment.
505?
Yeah, 5 of 5. And under line 21, you section 1-103, and you're down 2 Roman 2. Subsection 2 Roman 2. And you got 5101, and then the amendment to the amendment would be to add 14101 as well.
All right, so you're saying what, statewide, somebody is a detainer? Is this statewide? If you have a detainer, they cannot hold unless it's a 14101 or a 5101. Statewide now is a policy.
The policy would be that statewide you cannot honor a ICE detainer unless you're in one of those 3 counties that currently has the 287G and the person has been convicted of or charged with a crime of violence.
Well, wait a second. So if you're in Frederick County, we'd under that. But if you're in Washington County, doesn't have it, what is their prohibition?
They would not be able to honor the detainer. No, for holding, so there's 2 pieces of this. There's a notification and an actual detainment piece. So statewide, you would not be able to hold an individual beyond the time when they would be otherwise released unless you are in a 287G county and the person had been convicted of or charged with a crime of violence.
What is the point of what is?
The prohibition, so the 5101 and the 1401 still apply.
I mean, what it was is that-
You're not holding them anyway, right?
What is,
You shouldn't be able, I guess, so if you're in a county, you're like Washington County, and you've got a 14 in
So subsection B involves notification to ICE, and it states that, subject to an exception, a state or local correctional facility may not notify immigration authorities of any information for the purpose of immigration enforcement, and that the exception would be if the subject of the information has been convicted of or has a pending charge for a crime of violence. So that would mean that statewide, if you were holding someone on a charge or a conviction for a crime of violence, you could inform ICE that you had that person and when they would be released, but only in those 287G counties could you,
14101 and then the sex crimes?
for any crime of violence as defined in either the public safety or the criminal law article.
So you're incentivized, but then any county after this, if they join 287G, can't do this.
well, you can't join 287G.
Yeah, that's another problem.
Prohibition of 287G for joining
Yeah, statewide after this. So if you're in Frederick County, where's this any crime of violence part?
So it's currently in, on page 5 of 5 for the subsection A. It's
I
in
don't
there
even
in
have page numbers, that's the problem.
A to Roman numeral 2.
What were you going to say?
We're going to add 14101 to section 2?
To both of them.
To both of them, okay. So you're saying you want it, so like Montgomery County, if they choose. All right, I'll ask later. I think maybe there should be an or earlier here.
Yeah. So, Senator Bailey.
Help me, Josh. I got to go back to C. And just, I want to bring into some real life things that I've been involved with here, and I want to see how this affects it. You pick up somebody that's let's say a drug mule, and you pick him up, he's got a detainer, he is deported, right? 3 days later, I mean, they go to Houston, they go back. I can tell you, I've seen them a half a dozen times in 3 or 4 days. They're right here walking around again, right? They come back. And so is what it's saying there that the only place I can keep that person is in an area to the public?
No, so that subsection C3 is basically saying unless you're acting pursuant to a current 287G agreement, you can't allow federal immigration authorities to access an area that's not public. That is not specific to any particular individual. It's a general prohibition on doing that unless you're acting pursuant to a current agreement.
So I want to know how this affects the scenario that I just gave you. And let's say this person had been a drug mule, or
ICE couldn't have access to it,
what's that?
so they had to do it.
Oh, somebody that had not. Let's say they had.
And Montgomery
They were here. They could have been a serious offender, not a crime of violence, but let's use some real life examples, like that family that was killed in Queen Anne's County by the person that was illegally here and driving drunk, and we deported him, and then he came right back. Now he had it was a DWI, and it wasn't a crime of violence, and all of a sudden. What can I do with him as a police officer?
So if he's been charged with a crime like anybody else, he could be detained. Potentially, he could be detained pre-trial. I mean, that would be separate from this bill. I mean, you could not detain him beyond the period where he would normally be released under other law.
Well, so okay. So let's say he was in lieu of his charges, he was deported. Right? So we didn't waste the government's time or money. We deported him. And all of a sudden, in that walking down the street in that same jurisdiction where he was, Here he is again, a week later, same individual. He is not under charges at that point in time because he was deported, but he cannot legally be here, right? So he is then arrested. What happens to him at that point? Can we put him in the detention center and wait ICE to come and get him?
Is he arrested for a crime under state law, or?
He is federally deported. He cannot enter this country. He is not under current arrest, right? But he's not under current charges, but he can't be here, right? He's been deported multiple times because he's not under a current charges. His charge would be the fact that he's here illegally.
That's a civil
Yeah,
infraction.
state and local police
That's
would
not a
not.
civil issue.
It is.
Once you are criminally deported from this country, you come back. It
Yeah,
is
that is a criminal act, but being here, your unlawful presence is a civil
So
matter.
state and local authorities would not have the ability to arrest for that particular reason.
Better your scenario. I mean, come on, you're not going to. If someone's drunk driving, kills someone, you think they're really going to be released? You deport them in lieu of charges?
absolutely
Really?
yes. There are people that's exactly.
So you're saying
I've actually seen it where
You've seen-
we deport people. The ICE takes them, deports them, forgoes the criminal charges, and then because they need to be, they deport them, and all of a sudden that person is back right
No,
away.
I'm saying if someone kills someone in a car accident because they've been drunk driving, you're saying our government would deport that person in lieu of charges instead of having them go through a trial and go to jail here?
I'm just saying that happens.
I mean, that would be a decision for the local prosecutors to make.
But the issue is, right, a lot of our state and local police departments actually walk around with the authority of ICE agents.
In the detention center. Yeah. Only in the detention center. You can't on the street. That's what the 287G programs
Our three jurisdictions have been restricted to the detention centers.
Detention center. You cannot enforce.
Okay.
You could theoretically, but that's not what our agreements look like here.
Yeah, Frederick County, I believe, used to have that in their agreement, and they took that out of the agreement some time ago.
You cannot enforce on the street. State and local can't do that.
All right, so we go to Senator Castley.
I'm on page 5 still, and it says at the bottom in section B, as I understand that, if you have a 287G program and you identify somebody who's here illegally, if they haven't been convicted of a crime of violence, you can't reveal that.
That's correct. You would only be able to reveal that, generally the information would be that you have this individual and when they're going to be released. You would only be able to do that if they've been convicted of or charged with a crime of violence.
Or what about?
But what if our
No, this is the
agreement?
notification.
Okay, got it.
So, I mean, I'm not an expert on this, but you have an agreement with the feds to be able to access the INS records. So you bring somebody in, and they don't establish that they're U.S. citizens, so you do the search. They don't disclose to who they are, so you do the search of their records, and it pops up that they're here illegally. I thought that there was part of the quid pro quo with the feds for using that system was that you would notify them. So we probably wouldn't have access to their system at all, would we?
Well, the 287G agreements authorize that notification. I mean, the effect of the bill would be that either, if they're doing that, the practice would have to change, and perhaps the agreement would have to be modified.
Well,
There's all but two. Basically, you have to ignore detainers unless it's a 14101 or a 5101, correct?
Correct. But
All
you
right.
could share information with us. You just couldn't hold an
You
individual.
can't hold. So somebody comes in, you arrest somebody on possession of handgun, domestic violence, drug offense, child abuse, second degree, sex offense, third degree, human trafficking, assault of police officer, intimidation of witness, terrorist acts, hate crimes, any arson. They come up with a gang affiliation, any of that stuff. It's, okay, sorry, see you later, and they walk out. Are you allowed to then tell ICE that, hey, I released this individual who is a gang member and assaulting people?
Unless it's a crime of violence, no.
No, you're not. All right. So if you have a 287G program, what,
Almost everything you mentioned on that list is a crime of violence.
no, it's not. This is specifically things, these are
In
not
501.
14101s. Domestic violence, drug offenses, child abuse second degree, sex offense third degree,
So
burglary offenses,
Still
human
be 501.
trafficking offenses, commercial sex acts, involuntary servitude, most child pornography, exploitation of a minor, stalking, sex abuse of a minor only covers under 13, theft or larceny, intimidation of a witness, threat, gang charges,
501 and 14101.
Hate
should cover
crimes.
Both of those. Anything.
There's a ton of criminal charges that are clearly left off. So
Most of what you mentioned is covered either in 5101 or 14101.
no, it's not. I just read you the list of things that were not covered under there.
I'll pull up.
These are not. Look at human trafficking. That's not in there. Involuntary servitude. That's not in there. Show me that's a 14101. Human trafficking.
So 14101 includes a felony offense under Title 3, Subtitle 11, which is the human trafficking subtitle.
All right. What
But it would
about?
have to be a felony.
Yeah, felony. What about domestic violence? Isn't in there? Stalking isn't in there. There's a ton of crimes not in there.
So domestic violence is sometimes charged as a second-degree
Sometimes.
assault, which is in the public safety crime of violence, but it may or may
It's
not
not
be
a
charged that way.
14101. It's not a 14101. It is not. Stalking's not a 14101. The list I just led is not a 14101. There's a ton of heinous, awful crimes that are not 14101s. And not only that, but we all know ICE also sends these sometimes on just simple gang affiliation. So, but aside from that, so now all of our counties are basically going to pick up the sanctuary policy of Prince George's County, because Prince George's, they had this disastrous policy, and they at least went to the 14101, 5101. So you're putting everyone to the lowest level, which is, I think, the policy that Montgomery and Prince George's had. Actually, your county, I think, actually might have done a tougher policy. So you're going to basically the lowest level as far as policies in the state for everyone. If you're a 287G county, then what happens to you, though?
So under the two pieces, so on the detainer or the holding individual, you could do it for someone with a crime of violence, and that would also be true of the notification. As long as you have a crime of violence, if you're a 287G county, you can do the notice and the holding, the detainer.
Okay, but if you are any of the other plethora of terrible offenses that you come in on, if you come in on this human trafficking gang affiliation, we got to let you go. On a 287G or not.
It has to be a felony.
My understanding is commercial sex acts and involuntary servitude are not covered under this.
We look at section 501 of
I think it's the same language.
Yeah.
Assault on a police officer. I mean, we can go on and on. I'll gladly bring this laundry list to the floor, but there is a plethora of
It's the same,
offenses.
a felony human trafficking.
Assault on a police officer.
It's a felony. It's not a 14101. Intimidating a
Assault
witness.
of the first or second degree would be covered.
Is intimidating a witness. Is that a 14101?
I do not believe so.
It is not.
501. Not, but assault on a police officer would be 501.
When they hold, and another one they did on the form was suspected terrorism. That's on the actual form. That's not on here. All right, so this is the sanctuary bill. I got it. I understand now.
So moving on to the new provisions in the criminal procedure article on the unnumbered page after page 5 of 5. Subsection A is definitions. Subsection B would be a prospective ban on local jurisdictions entering into 287G agreements or any similar agreements with the federal government. Go ahead.
Is under, and I don't know how long when they expire. You'd have a 287, I know they have to keep re-signing them, so once they expire, you couldn't re-sign. I know they're for a term, I don't know what the term is, but I know 287G programs expire, and they have to keep re-signing them because they change the feds updated or changed the terms, that kind of stuff.
I don't think that's directly addressed in the bill. I'm not sure that the intent was to require them to expire, so perhaps a clarifying amendment could be added.
Can I just ask, regular police functions, it's in C1, it says except as provided prior, a law enforcement officer may not, during the course of performance of regular police functions, inquire about individual citizenship, immigration status, placement during a stop search or an arrest, detain or prolong detention. So normally the arrest, so I'm not sure what that means because, is it the arrest on the street or is that as you're processing the person in the detention center and now they're in the detention center?
The way I read it, I don't believe that would constitute the arrest still, although I can't guarantee that that's the way that, if it went to court, that's the way it would be interpreted. However, I would note that one of the two exceptions to that prohibition is that the law enforcement agent can inquire about information that's material to a criminal investigation. So it's not a prohibition without any exceptions. So just to continue on subsection C, as Senator Castley noted, it's a prohibition on law enforcement agents, during the performance of regular functions from inquiring about citizenship, immigration status, or place of birth during a stop, search, or arrest, from them detaining or prolonging the detention of an individual either for the purpose of investigating immigration status or based on the suspicion that the person has committed an immigration violation, from transferring an individual into federal immigration authorities unless required to do so by federal law, or on coercing or intimidating or threatening the individual or a related individual based on actual or perceived citizenship or immigration status. And there are two exceptions to this prohibition. The first is that they may ask about any information that is material to a criminal investigation. And the second exception would be that if their citizenship status is relevant or their immigration status is relevant to a protection or requirement under law, the law enforcement officer may notify the individual of that and give them a chance to voluntarily disclose the information. And then finally, subsection D provides that without a judicial warrant, a law enforcement agent may not, pursuant to a request by immigration authorities, either transfer the individual to federal immigration authorities, detain the individual for the purpose of immigration enforcement, or notify immigration authorities of certain types of information.
So the transfer that you just referred to under D1, if you have a 287G program and it was up and running, you still couldn't deliver the person to the federal immigration authorities.
Correct, and current 287G agreements in the state, they don't allow these kinds of, they don't cover these kind of transfers outside of the correctional facility. So that's currently not a practice that's happening in the state.
Wait, I'm sorry, I'm not, this D1 would apply even inside the correctional facility.
Yeah, although it would apply to law enforcement agents as opposed to the correctional facility agents or employees. So yes, it would apply if the law enforcement agent is
Well,
in.
I'm sorry, I mean, law enforcement agents in most of our jurisdictions, like, they're employees of the sheriff's department. They have certain policing authority. They're covered under the correctional officers' Bill of Rights. They do have certain policing authority. They don't police outside the detention centers, but they do have law enforcement powers. Why wouldn't they? I mean, that would say even if I'm holding somebody on a crime of violence, I still can't transfer them to the feds. And just to back up, I'm concerned about this inquiring because So now you've processed somebody, they're under arrest, they're in the detention center, now they're going to go for a bail hearing, and they're going to proffer, and if I don't know where they're from or what their immigration status is, I'm going to go say, well, he says he lives down the road. He's got some friends down there, and that's who he lives with. I can't tell the judge, no, actually, he came across, he has no, I don't know anything about this guy, but the INS has him that he came across the border 2 days ago, and he's heading for New York, and he's just stopped in here on the way. And he's likely on this crime of violence that I'm releasing him on. He probably won't be here within the next hour once you release him on bail.
I don't think there would be a prohibition on using, if you had information on his immigration status.
But how would you have, the way I read this section, it applies to law enforcement. It says that, except as provided in paragraph 2 of the subsection, a law enforcement agent may not, during the course or performance of regular police functions, inquire about the individual's citizenship, immigration status, etc., on a stop, search, I got the stop and search, or an arrest. It seems to me the arrest is in the detention center. You book them in the detention center. It's all part of the arrest process. So now I can't even tell, I can't even inquire, so when I bring them up for the bail review, for preliminary hearing, I won't even know. I won't even know that. He'll just say, yeah, I lived down the road. But the guy I was just sitting with for a second, I'm going to give his address, and I won't be able to say, no, he's not a U.S. citizen, and I did my INS database search, and they haven't crossed on the border 2 days ago.
I mean, I believe when it says that, you can't inquire, I mean, perhaps it could be clarified, but I believe that is really referring to you cannot ask them. If you
Yeah.
could find out through other means, the way I read it, I'm not sure that
I'm
would
not sure how I do that,
be-
because he's not in our fingerprint database, and other than asking the person where you're from and trying to determine that, and then running checks to verify that, I don't know how you would know. I mean, you would say, where are you from, and then you start asking him some questions to verify, ask him for, you say you're from Towson, Maryland, and then you say, oh yeah, where do you like to hang out? Do you know any restaurants? Do you know any bars? Nothing, no place. What's the nearest other location to Towson? Oh, I can't name any of them. I can't name anything. You don't know anything about this area? Nothing. And you're telling me you live here? Yeah. But we can't ask about that. Because I can't say where were you born, what are you a citizen of, what's your immigration status. I just have to go before the judge on a preliminary hearing and say, this is Joe, he says he lives at this address. Judge, if you want to let him go, we just charged him with felony assault. But he's got some money here from somewhere, he's going to post the bail, and then you're going to let him go, and he's going to be gone in 5 minutes. I'm just looking at the way it's written right now.
I mean, you could not directly ask those questions about place of birth or citizenship, but certainly ask questions, where in Maryland are you from, or do you know the area that.
Right. I guess we're going to apply this to all of us now, so if I get arrested without my driver's license, and they can't ask me anything about, am I a citizen, where was I born, I guess they could ask me for me, they got me, because all they do is just say, well, let me see your fingers a second, and I show up at a fingerprint base in 2 seconds, right? So, okay. Yeah, this is okay.
Is that it? So you're going to speak on it today? Kelly? No? Speak on it today? Go ahead.
The next page, section D, says without a judicial warrant, law enforcement agent may not, pursuant to a request by federal immigration authorities made in relation to immigration enforcement, transfer an individual to a federal. So even if you have a 287G program, we're clear you still can't transfer them, right?
That's correct.
So we're nullifying. I mean, the 287G program kind of becomes. We just gutted those because if you can't transfer them to the people, you're gonna let them go. It's like, well, why am I in this program? Because you just released everybody. So
I would have to double check just to make sure that the definition of law enforcement agent that's used doesn't include the correctional officers as well. I would have to just verify that that's the case, but because it is a defined term earlier in the section, and it refers to the definition in 3101 of public safety, I could review that and just make sure that's the case.
Thank you, Mr. Chairman. So, Council, if you could just clarify something for me. So, I make an arrest on the street of an individual, and I take them to the processing, whether I'm taking it to my agency or wherever. And, there's a typical formatted document that you have that has all identifiable information on there. That is reasons for that. One is to identify who you have with you for officer safety reason and for the safety of the public. And two, if you ever have to look for that person if they don't show up in court, you need to have those, have that initial information. And for investigators, you get better at it each day to begin to have folks to give you information. So are you saying that an officer who makes an arrest of an individual on the street, takes them in for a crime, an alleged crime, and they process them, and they have to present this person to a magistrate, for bail, review, or hold them over for the next day, depending on what's going on, that I cannot do a workup sheet on that individual? I mean, so how do I know? I mean, the courts need to know who to send information to have them come to court. They were arrested. They were charged with a crime, whether they were released on their own recognizance or whether they made bail. We need to know who that individual is from an officer safety standpoint. So I don't think that's the intent of this, but the more we talk about it, the worse it gets for, everybody's safety. You have to know who the person is. I get arrested, you have to know who I am. To the courts, I mean, not everybody's a John Doe. And we have interpreters, and, so I guess I need to understand that a little better. That's definitely disconcerting for any of the folks in law enforcement that's out there. You need to know who you're dealing with. Officer safety, that's basic. And you really can't be restricted of, now if I stop someone on the street, I mean, and ask them, are you a citizen? I mean, look, that's just nonsense, or it can be construed as nonsense or whatever. But, so I guess I need to know where the line is. And if the line is that once I arrest you and I get you back to the processing center and before I hand you off to the regional processing folks, there's a packet that I need to have because I need to know for my files, and I need to know, when the state's attorney calls me back to screen this case. So I would certainly need to know more on this bill.
Yeah, I mean, the prohibition is on citizenship, immigration status, or place of birth. So, I mean, you're more familiar with the information that will be required than I am, of course, but, name, address, where you live, that certainly would not be covered by the prohibition.
It's part of the basic processing of an individual. I mean, that's identifiable information that is needed. Again, I think I know, maybe where the sponsor is going with this, but I think, we really cannot restrict the criminal justice system of having pertinent, identifiable information. So.
You talk about the exception for the tenured criminal investigation.
Right, so in addition to that, to the extent that the information would be necessary for the criminal investigation, so I believe maybe at the hearing, the hypothetical came up that the crime being investigated may involve, moving across the border, bringing drugs, something like that. So, you could certainly ask them if it's relevant.
I need to know who I'm processing. And, again, there's a basic form, there's an investigation that goes into place after the arrest, after the processing, and then the criminal investigators or the arresting officer then does what they need to do to prep for court. But I'll keep listening.
Go ahead.
Thank you, Mr. Chairman. So my question is, if somebody is arrested for one of the parade of horribles that has been mentioned, that is not listed in 14101 or the other section, 5101 or 14, whatever it is, they can still be arrested, correct? And charged, and then a warrant issued, right? So it's not like we're, right?
Warrant issued by whom?
I'm sorry, I didn't hear.
A warrant issued by whom?
By a judge.
ICE doesn't issue a warrant, that's the issue, it's a civil detention.
But if you're talking
Yeah,
about
but I'm
any of
talk-
those underlying criminal offenses, you're right. So yes, you'd be arrested and charged and detained, pre-trial if necessary, yes.
Right, so it's not like we're letting all these people going free, right?
From an immigration judge, you are.
From the criminal justice
But not
system,
after
no.
you've been
Yeah.
charged with a crime.
No, the purpose is that coming in the country, when you come in the country illegally, it's a civil offense.
Right,
And so they issue a civil detainer, ICE does. And what they're trying to do is they want to get you in front of an immigration judge. And if we have our facilities decide that somebody comes in and they're one of these crimes that's not listed. Let's take 4-503, which is possession or creating a destructive explosive device. That's not covered in what the bill is in front of us. So we've got somebody who's making explosives, and then if they get bail or whatever happens in our system, if the detainer is ignored and you just let them out, they'll never get in front of an immigration judge, and their immigration portion will never be dealt with. And so therefore, the person would probably be deported. And so if you've got somebody who, on the parade of awful offenses that I can read through, they're just going to walk on out, and they're not going to get in front of an immigration judge. They've already come in the country, and then they probably skipped out on their first immigration hearing, and you're just trying to get them in front of an immigration judge. And that's all the detainer is asking, is to hold them to get them from an immigration judge. And when you ignore that, they just will walk out, and you're not going to take care of that portion of it.
So what would happen is if you're enmeshed in the criminal justice system, you'll come back through, even if you're somehow, you're let to go pre-trial, whatever. You'd come back, and if you do get convicted, then obviously all bets are off for this. They can notify. What? Yeah. Just for the programs, right?
It's for the crimes of violence.
For the 14101s or.
He's saying they couldn't for non-crimes of violence.
Yeah, but you're still. I mean, it's not like you're like what the senator's saying is that you're not going to walk away free.
Not necessarily. No, that's not accurate.
You're still going to be.
It depends
subject
on
to the
what it
criminal
was. If
justice
it's a
system.
drunk driving, you could easily walk out that night. You could easily walk out that night, and no one will ever see you again.
But you'll still be.
You will
under
not
judicial
get held
supervision.
in Frederick County if you get a drunk driving and they run you right now. And quite frankly, they don't even use the underlying offense. That's what I don't understand. ICE is looking at sometimes the underlying offense, but ICE has other reasons too they might want to hold you. Suspected terrorism is one of the things on the form. I have the form. If I knew we were bringing this up today, I would have showed you the Obama-era form. And the Obama-era form had serious charges, had felonies, had serious misdemeanors on here, which you're lacking in this bill. And it also had things like gang affiliation. It had things like suspected terrorism it had on there, which yours bill totally is lacking right now too. And not only that, there are a number of crimes on here that I'm looking at on this list. I just made off the top of my head. Like child pornography, is that covered? It's not covered. Somebody comes in the country illegally, has tons of child porn, and we're not going to turn them over to an immigration judge? Like, that's outrageous.
So, that's, if we go to C1I, and it says, inquire about an individual's citizenship, immigration status, or place of birth during a stop, a search, or an arrest. Right? Okay. So the first thing, somebody commits any criminal act in the state of Maryland, and the police officer, and they do not have a satisfactory form of identity, there is no alternative other than to arrest that individual. When you arrest an individual, first thing that happens before they can go, when you walk into a detention center, or before they go before a commissioner, first thing you have to do is fill out fingerprint cards. You know what's the first thing you put on a fingerprint card? Citizenship and place of birth. Says you can't do that. So I mean, right, now we got a catch-22, because we just passed this police reform that says, wait a minute, you got to follow the rules. Now you got a guy that you just put here in this trick bag that say, wait a minute, what do you do?
Yeah, you're going to show badge ID and all that. So the police officer's going to show their badge ID and number. And they go, and the actual criminal doesn't have to show his ID.
Right. I mean, this is wrong. You can't do this right here. This does not make any sense whatsoever.
We'll be back at 10 o'clock tomorrow morning. Yeah.